Hello and welcome to the Rocky Mountain MS Center's webinar series. This series is designed to give people with MS information to empower them to make the best choices for their lifelong brain health. I would like to thank the pharmaceutical companies who have provided support for this program. Thank you to Genentech, Novartis, and Sanofi Genzyme. Today's topic is estate planning, the basics everyone should know. Before I introduce our speaker, I also want to mention our next MS educational program, Conversations on MS, happening on Tuesday, February 15th at 6:30 p.m. Mountain Time on Zoom. Conversations on MS is a virtual town hall style audience-driven event. Dr. Anna Shaw from the Rocky Mountain MS Center at University of Colorado will be answering questions submitted by the audience for an hour and a half about all things MS, like symptom and lifestyle management, research updates, and treatment options. You can sign up for this and all of our events by searching for the Rocky Mountain MS Center on eventbrite.com. Make sure you're signed up for our email list to get updates on all educational programming. This presentation on estate planning features Mr. Thomas Wolfe. Tom is an experienced litigator and trial attorney with Ireland Stapleton Pryor Pascoe. He represents companies, executives, and entrepreneurs in complex civil litigation. He has served as lead counsel in many jury trials in state and federal courts around the United States, and he is known for his swift and calculated approach to matters involving trade secrets, unfair competition, commercial lease and finance, breach of asset purchase agreements, computer fraud, real estate development and lending, real estate partition, contested probate, commercial fraud, and minority shareholder claims. Tom helps his clients with tailored and thoughtful estate planning solutions to preserve their legacies for generations to come. This webinar features a lot of important information. If you missed something on a slide or want to hear it again, we are recording this webinar and it will be archived on our website, mscenter.org, so you can replay it at any time. All live viewers will get the recording automatically sent to them. You will also receive a link to our evaluation survey. Please take a few minutes to fill this out to help us improve future programming. We'll reserve time at the end of this discussion to answer questions from the audience. You can submit questions at any time by typing them into the Q&A box on your screen. We will answer as many questions as time allows. Today's presentation is for informational purposes only. All decisions regarding legal matters should be discussed with your own attorney. Tom is a licensed attorney in Colorado and is unable to answer questions specific to other states. With that, I'll turn it over to Tom Wolfe.
Hello, it's good to see you today. As Kelsey said, I'm an attorney. I've been an attorney for 40 years in Colorado. I'm wearing a tie today. In the last couple of years with COVID, I've not been wearing a tie, and it's fun to wear it. I feel like I'm talking about something that's very, very important. I'm not your lawyer, but I'm giving you an overview for estate planning through this webinar. So please listen to what I have to say, and you can give me questions at the end. I'll be happy to hear from you. I'm going to put up the slides now to look at. This is the beginning of the plan. It's called estate planning, the basics everyone should know. I call it the basics because that's what they are, but there are many issues to talk about. Oops. There we go. This is the information about me. It will be in the webinar that's being taped. Now, this is the agenda for today. We're going to talk about wills, powers of attorney, medical powers of attorney, living wills, trusts, and probate. These are a lot of different areas, and we'll go into each one of them as we go on. There's something I like to tell people about estate planning and probate in Colorado. Many people call me and they say, if I don't do my will or I don't do my accounts, the state is going to get my will, my estate. The state, Colorado, or the federal government, they're not going to get your estate. Even if you do not have a will, your descendants will get your estate. You see in this slide the different ways it works when you pass away if you don't have a will. It goes to your children or to your spouse, then it goes to your parents, then it goes to your parents' siblings, and it goes to your cousins. In the end, it can go to many different areas, but it will not go to the state or the federal government. It goes to the people that are your descendants, and they will be found by the lawyers that start up probate for you. So don't worry, your estate is not going to the state. It's important when you start working on estate planning that you talk to your family. It could be your family or your friends or people that you trust. You could talk to them about the decisions you're going to make while you're making your estate plan. You could talk to them about who your fiduciaries are going to be and who your beneficiaries are going to be. The fiduciaries are the people that you appoint in your will or in your power of attorney to do your will. The personal representative in your estate is the person that manages your estate when you pass away. The beneficiaries of your estate are your descendants or others that would get your assets from your will. These are the things to talk about with your family so they can understand what you're doing, and in the end, what you will do in your probate plan. These are the documents for an estate plan in Colorado. We have wills, powers of attorney, medical powers of attorney, living will, personal property memorandum, and a tissue bank, are also called organ donors. I should also tell you that when you do a will, months later or years later, you can change the will by what's called a codicil. C-O-D-I-C-I-L-S, codicils. A codicil is an amendment to the will that you can do later in your life, or you could do a new will if you'd like to. A will is a document that is self-proved if it's signed by two witnesses and a notary. If they both do that, this will be probated in Colorado without an issue. It won't be contested. It's a good will that will be followed. The will, as I noted, will appoint the personal representative of your estate when you've passed away to work on your estate. The personal representative will gather your assets, will pay your bills, and then deliver your assets to your beneficiaries. It could be your children, it could be your parents, it could be your friends, and it could also include a charity. The beneficiaries can be divided up to a number of people and charities, or however you want to do it. Wills can be done the way you want them to be done. If your children are minors, and something happens to both of you and you and your spouse, the assets will go to them in a trust in the will. They will held in trust until your children reach majority, 18 years old. A powers of attorney is a document where you appoint somebody to run your finances. It allows that person to do them for you when you can't. You might be injured, you might not be able to make decisions. So the power of attorney appoints a person, parent, spouse, friend, to run your finances. It's a good document. If you have it, it will help you in the rest of your life. I use my mother did a powers of attorney for me and my siblings. And we managed my mother's estate for 4 or 5 years until she passed away. We were willing to do what she wanted, and we were able to do it with the power of attorney. The next document is called medical powers of attorney. It's the same as a power of attorney, except it's for medical decisions. These are to be made when you can't make those decisions. Many times, the fiduciary, the person that you appoint in the power of attorney, might be different than you appoint in the medical power of attorney. It's a person that can help make decisions about medical decisions if you can't make those decisions. Everything that you have in your will pass to the beneficiaries. It's real estate, it's securities, it's cash, and it's also called personal property. Personal property are things that do not include cash, securities, or real estate. It's things like antiques, cars, and other things that you want to give to people. It passes through your will, but if you would rather do a personal property memorandum, you can do that on your own. If you don't do it, the personal property will go through your will. I represented a woman who had no children, and she had a lot of cousins. Her personal property memorandum was 26 pages long of all the special stuff she wanted to give all these people. When she passed away, we did what she wanted, and it was a good thing for her to do. The last item here is, oh, by the way, is the living will, and I didn't talk about that. A living will is a declaration as to medical or surgical treatment. This is a document that you will sign, and that document provides that if there are two doctors that decide that you are in a terminal situation, you sign the document that says that you want medical care cut off. Then you can have nourishment cut off, and what it will do is keep paying to you until you pass away. I prepare a document that's several pages long that you could look over and decide what you want to do. You could choose to keep nourishment for a couple days or months, whatever you want to do. But this is a document, we call it an end-of-life document, where you make decisions about what's going to happen when you are terminal near the end of your will. A tissue bank or an organ donor is something that you can put in your driver's license. You can be an organ donor and your body will be used and donated. Sometimes it's important that if you have MS, they want to study your tissues and your brain, and that's the way to do that. It's important that you talk to your family about this. You may decide that you want people to use your body for science and to help other people, but other people in your family may not want you to do that. So it's important that you discuss it with your family and they understand what your decisions are, so that when you pass away, your body will be used as you wanted it. If we've done all these documents, your estate plan is in place and you can move ahead. And as I said earlier, you can update the will with a codicil later in your life. Again, as long as you have two witnesses and a notary. And the reason I say that is because the will becomes self-approved in the probate. Many people think about trusts in Colorado. They're called revocable trust and irrevocable trust. Colorado's probate is not complicated. It's not expensive. It's not difficult to do in Colorado. Now, if you live in California or you live in Texas or Florida, a trust may be important so that you can avoid doing probate. I've been a lawyer for 40 years. I've done thousands of trusts. I've probably done less than 100 trusts. Occasionally I use them in specific situations, but in Colorado, a trust really is not needed. An example would be that you've done a power of attorney for a person to manage your finances. That's fine. You don't need a trust to do that. Or a medical power of attorney. You don't need a trust to do that. But a trust can be used. A trust is a document that you appoint a person to be your trustee. The trustee will be the person that manages your finances, manages everything you have, and then gives it to the beneficiary. A revocable trust is a trust that you can set up, but you can always terminate it in the future. An irrevocable trust is a document that can never be changed in the future. Once you set up an irrevocable trust, it can't be changed. I will note, though, in the years as a lawyer, and maybe 2 or 3 times in my life, we went to court and had a hearing and did change the irrevocable trust because the plans that were made were not working. There are special needs trusts that are typically irrevocable, and those special needs trusts are given so that the person can still receive Social Security and it's not impacted. The special needs trust can help people that need help beyond what they're getting from Social Security. So next we could talk a little bit about the decisions you need to make. We talked about those in talking to your family. I understand that people have asked about who's going to be my fiduciary, who's the person that I trust to make decisions for me in my probate when I pass or in my power of attorney. Typically, people rely on their family, siblings, children, parents. You can also use a close friend. They are people that you trust to make decisions, and they will follow what you say. The fiduciaries are the personal representative in the estate, the person that runs your estate, and they are the agents that you appoint in your powers of attorney. If you decide to revoke the power of attorney, you do it in writing and you let people know that have your power of attorney. If your power of attorney is at the bank and you want to revoke it, do it in writing and send it to the bank. It doesn't happen that often, but when it does, it can be done that way. Now, the beneficiaries of your estate. Many people, I've had people that they gave their entire estate to a charity. I have other people that have given their children their estate, or their siblings, or some of their friends and cousins. Beneficiaries of your will are persons that you can think about with your family that will get your estate at the end. Also, you should know there's beneficiaries of your insurance trust, insurance, I should say. Insurance pays to the beneficiary. Again, when you pick the beneficiaries, you can divide it up between family and friends and essentially charities also. Finances and healthcare, talking about managing your finances and medical powers. As I told you, when you do a power of attorney, that person, when you can't do it, will help you manage your finances. As I said, I did it for my mother, and she was fine to let me do that. I will say, just so you know, I had 3 siblings and we were all adults, and she wouldn't let them know what's going on. And I kept telling her, to my mother, please let my siblings know. And finally, after a year or two, she said, okay. And so every month I sent copies of the statements to my siblings, and they now knew that I was doing a good job. It's important. If you have a power of attorney, you do not need a conservatorship. A conservatorship is an action that you can file in court. You file a petition for conservatorship in the place where you live, or the person does it, and the court then would determine whether there should be a conservator appointed. Another person will make sure that you might need one, and one will be appointed. But you don't need that if you have the power of attorney. Again, a conservatorship can be done. It's expensive. It costs a lot of attorney's fees. But in the end, if you have the power of attorney, you won't need the conservatorship. You might remember that you've heard about some famous conservatorships. One might be Britney Spears. She was under a conservatorship for 20 or 30 years that her father managed. She finally, in the last year, got out of that conservatorship and now is on her own. We know she had many issues, and that's why he did it. And that's why he did the conservatorship. She never wanted to be under the conservatorship and always fought it. In the end, it was over. With a medical power of attorney for medical decisions, you can also use the court to appoint a guardianship. A court would appoint a person to be your guardian to make medical decisions for you. Again, it's like a conservatorship. It costs a lot of money. It can be a big issue. But if you have the medical power of attorney in place, that will give the person that you gave the power to make decisions for you. They don't need to have a guardianship and go to court and get that done. I wanted to let you know about these things so that you know there's different ways to go. Now, we've done the estate plan, and now we're talking about probate. Of course, probate is when you've passed away. Can you do a probate without a will? With a will, and what about a small estate affidavit? Without a will, your estate will not go to the state, it will go to your descendants, as I noted at the very, very beginning. If you have assets that can be managed, an attorney will file a probate action and say that you did not have a will. And then the court will determine who, under what's called intestate, I-N-T-E-S-T-A-T, intestate succession, who your beneficiaries are. It will work out. I remember years ago, I was doing this for a person who had cousins all over the United States. And I called a cousin in Ohio and I told him, well, guess what? Do you remember your great aunt? And he goes, I don't even know who she is. And I said, well, guess what? You're going to get $250,000 from her estate because you are in her will and you're going to get that. And the first thing they asked was, how long is that going to take? I eventually got it to them and they would be happy, but just an essential way that that happens. Now, if you have a will, your estate will be probated, and it's called with an informal probate. If there's no will, then we would do what's called a formal probate. We file the petition and the judge has a hearing and determines who your descendants are without the will. If you have a will with 2 witnesses and notary, the wealth will be proven and there will not need to be a formal probate. It will be called an informal probate for the will. An attorney will file a petition for probate, an informal probate, and the court will appoint, without, it actually be probably a magistrate, appoint the personal representative in your will, and then that person will go ahead and gather your assets, pay your bills, and then deliver to the beneficiaries of your estate. There's a will called a holographic will. Holographic will. That's a will that doesn't have 2 witnesses and a notary. I want to say one thing. If you do get witnesses and a notary, it can't be somebody that your will gives money to. It's somebody that's separate from your family. Now, a holographic will is something that can be written in handwriting. Typically, that can be a holographic will, or it could be a typed document with a signature that you want to be your will. The probate court can determine whether your holographic will be the will for your estate, but it will be by formal probate. The probate petition will be filed and there will be a hearing by the court to determine whether the holographic will is appropriate. If the court determines that it's not appropriate, your estate will pass without a will under intestate succession. Now, is our wills contested? Wills that are properly witnessed and notarized are hardly ever contested. Holographic wills may be contested, and there may be 1 or 2 that exist. In the years that I've been an attorney, there's been very few wills that were contested. When it happens, it's a very difficult situation. In the end, it costs a lot of attorneys money, but a contested action can be done. I probably in many, many years did maybe 10 or 20 of those. I was talking to a friend of mine the other day. My wife's Greek. He's an old Greek guy. And he said that his great aunt passed away and there's about 12 or 15 cousins and they're all expecting their share of her will. And I said, well, have you seen the will? No, not yet. It hasn't been filed. I said, once the will's filed, you can look at the file and determine whether you cousins are going to get what you think you might get. Don't be surprised it's not what you thought. It turns out that the cousin that took care of the great aunt is the one that's going to get most of the estate because she took care of the aunt. Another way to do probate is what's called a small estate affidavit. It's a document that you prepare as a descendant or a relative that cash and securities are less than $70,000. Less than $70,000. If you have that, you can do a small asset affidavit without probate, and the person that sets it up can transmit those assets to the beneficiary of yours. One way to look at a small asset affidavit is your accounts may be in joint tenancy, or they may have a pay on death. And if all of those accounts are in that situation, you won't need to do probate. The small estate affidavit will occur for things that might not have been covered in the joint accounts that are in each other's name. An important other way to transmit real estate in Colorado is what's called a beneficiary deed. A beneficiary deed. With your home, you file a beneficiary deed with the recorder, and the beneficiary deed says that you own your home. But when you pass away, title to your house passes to the people that you put in the beneficiary deed. It might be siblings, parents, or children. With that, in the small estate affidavit, we have avoided doing probate for smaller estates. As I noted, if you have accounts that can be paid on death, they will not have to go through probate, and we won't need to open probate to do that. People ask me when I'm doing probate and estate planning whether they should pre-plan their funeral. In all the wills and estates that I've done, maybe 15 to 20% people pre-planned their funerals. The advice I can give you is that you need to go to a respectable funeral home. In Colorado that I know, there are many respectable funeral homes. You can go to them and talk about what you're going to do in your funeral. This is not a good thing to talk about, but it's something that if you decide to do, it will help. You can determine whether you're going to have a casket, a burial plot, or you're going to do a cremation, and you write it all down with the funeral home. Then you make payments over time to pay it off, or you bought insurance to pay it off when you pass away. If you pre-plan, there will be no issues for any of your descendants or friends that maybe not understand what's going to happen. It's a good thing to do if you want to do that. One more thing I wanted to talk about is in Colorado, there is a Colorado End of Life Option Act. It is a recent statute that allows people that are in a terminal illness and they have less than 6 months to live. They can go through the probate process to obtain, I believe it's the drug that would end life. Very few people in Colorado have done it, but the ones that have done it, their family has learned that it worked out well for them. It's not used by many, but it is in trust, and it's an important thing for us in Colorado. I didn't mention at the very beginning that my wife's brother, Laura's brother, had MS. He had it for 30 years when he finally passed away, and I worked with MS and other societies to kind of help his life. He was a great man. He was full of life, and he knew how to make each day better. My son is now a special eds teacher, but when he was younger, he took care of his uncle when he had MS. The whole Greek family helped him and made his life better, and he was a good man. Now, if you'd like, we can talk about questions. It didn't actually go that long, so I'm happy to look at questions if you want to send them to me.
Thank you, Tom. You guys can continue to enter your questions into the Q&A box on your screen. We have had a couple submitted, and we also had a few submitted at registration. So we'll get started with those. And I just wanted to remind folks again, we're unable to give specific legal advice. If you have questions relating to your specific circumstances, please consult with an attorney. For the beneficiary deed, is there a limit on the value of property?
It is not limited on the property. It's typically only used for homes, residential homes, but it could be any house in Colorado. You prepare the deed and file it, and it will manage your estate without probate.
With minor children as beneficiaries, do you recommend a trust or power of attorney, or what is the primary difference?
A primary thing will not work. What you do in your trust, you don't create the trust outside the will. The will is created in your trust. It's what's called a testamentary trust. So if you pass away, and when you pass away, your children are minors, the trust in your will come out and be in place until your children become older. I've done that for a lot of people. And like I said, I may have done it 30 years ago. Now their kids are adults, so their trust won't come out in their will because their children are now adults.
Kind of backing up to very general, when is it beneficial or even necessary to have an attorney prepare estate planning documents rather than doing it yourself with an online service? Do you need to hire a lawyer, an estate planner? And do you have any idea of the range of costs that might be involved in that?
I mean, I recommend that you use a lawyer to set up your estate plan, the documents that we talked about, the wills, the powers of attorney. That's the best way to do it. If you do it online, the will might not be properly signed. An attorney can give you the advice that he or she learned in his life as an attorney about what he expects for you. So my hourly rate is $540 an hour, and that's a big rate, right? But if I was doing a basic estate planning will, maybe just a basic will with powers of attorney, it probably might cost between $1,000 and $2,000. But as we get more and more complicated, if we decide to do trusts and other things, it becomes more and more expensive as we get make it more complicated. Again, I'm not giving advice, but if I meet with people and they come and they talk about what they want to do with their estate plan, I'll sit with them and tell them after we talk about it and make a decision, I'll tell them what I think it will cost, so that they know what they're looking at when they go forward.
What happens to your estate if you have no descendants or beneficiaries?
But you do, because under intestate succession in Colorado, an attorney will find a beneficiary somewhere that is a descendant of yours. Now, of course, you could also give your estate to charity. And I'll tell you that I've done a lot of estate planning where people say, if they don't find any of my descendants, I'd prefer that my estate goes to charity.
What should someone consider differently if their estate plan includes assets that are held in more than one state?
Okay, as I stated, I'm a lawyer in Colorado, and I have clients that have vacation homes or other property in other estates. There's a couple ways to do that, and a lawyer would help you with that. You can take real estate in other states and put it into a Colorado LLC, limited liability company, and that way you wouldn't have to do probate in those estates. If you don't do that, you'll do probate in Colorado, but you will also have to open what's called ancillary probate in other estates to manage those. It's better to not do that if you can, when you're doing your plan, putting stuff into a Colorado LLC so that you don't have to do a probate in another state.
For the small estate affidavit, do all descendants need to sign that, or can a durable power of attorney file that?
It's not usually an attorney that does it. What will happen is when you pass away, it's going to be a child, a parent, it's a relative, and they have a right to do the affidavit on the basis of how they're related to you. Attorneys typically don't do it. You sign it, and then you gather the assets and then distribute them.
Can a personal articles memo be simply a handwritten and signed and dated that one keeps adding to as an ongoing document?
Can you ask that again, Kelsey?
Yeah, can a personal articles memo be a handwritten and signed document that you can keep adding to as an ongoing document?
You can, of course, but remember, as I noted, it's just for personal property. It cannot be used for cash, securities, or real estate.
We did have a couple of other questions that came in about folks who don't have beneficiaries nearby or family nearby. So if somebody is single, living alone without family nearby, what do they need to think about for how they would be cared for in an emergency? And then also kind of in that vein, what questions would you suggest asking to find a reliable, honest trust service or attorney? What do people need to think about there?
If there are not people in the state or that cannot help you in the state, years and years ago, I did some estate planning and probate for Colorado teachers. They were DPS teachers in Colorado, and they were women that never were married, and they taught and they taught and they taught. They became old and they retired, and they had some assets. They had no children. They had nobody here. And the question was, what should we do to this person? And so one thing we could do is have her appoint somebody with a power of attorney or medical power to manage her estate. But the other thing would be, and this is the one I talked about, if you have to do a trust, if you're an elderly person, you're by yourself, and you need somebody to manage your affairs, it might be worthwhile to set up a trust for you. Now, who would be the trustee? If you don't have a friend or somebody that you trust, the trustee would be, could be a bank with a trust department, or we could find somebody in Denver or where you live that would be the trustee of your trust. There are those in Colorado that do that, but you need to, if you should talk to a lawyer about that, and that person can help you find the right person to do that.
And when you're, if you're just starting out, you don't have a will, you don't have an established relationship with an attorney of any kind, what are some good questions to ask when you're looking for an attorney? Any tips on finding someone reliable and good for your own situation?
Well, I mean, you need to find somebody that can do a good job for you. A lot of people, when they start practicing law out of law school, if they're practicing by themselves, they might be doing estate planning because it's kind of, they're trying to learn how to do it. But I think that, we have lawyers in Colorado that are best lawyers in estate planning, super lawyers for estate planning. There's different ways to look at how lawyers are reviewed. You can look those up and find out one that might help you in those areas. It's having somebody else say that lawyer, a woman or man, are good lawyers and can help you with estate planning. Some estate plans, depends who you talk to. Some lawyers, estate planning are very, very expensive. Others are not. Having that first meeting that I don't charge for the first meeting. You have the first meeting, and I can tell you, as another lawyer would do for you, if you go to them, would tell you what they think it will cost. If you think it's ridiculous, then I think you should find somebody else that will make it work for you.
How often should folks be reviewing and renewing, I'm going to say both their wills, and then if they have a trust in there, how often should they be looking at that again?
Well, that's a good question. I started a law firm that started in 1963, and I joined in 1981 before I came here. And in our safe deposit box at the bank, I have some wills that are signed in the 70s, maybe some in the 60s. And I typically don't call them all the time about updating their wills. The fee agreement says that if you have questions, you can ask about it, but we don't keep telling you what's going on. So I'm 40 years old now. I'm looking now at wills that I've done maybe 20 years ago. The people that did these wills, their kids are now older. They have a larger estate or a smaller estate. And so they call me and said, hey, what do you think? Should we do this and do that? In some of them, we do a new will. In other ones, we do a codicil. In the others, we don't do anything. So it's, I guess I would tell a person, maybe things may change. If something changes in your life, you should call the lawyer. But otherwise, maybe every 5 years, give the lawyer a call and say, what do you think? Should you do anything? And a good lawyer will tell you yes or no.
If somebody has their estate planning documents prepared in another state and then moved to Colorado, are the documents prepared in other states generally good, or should they look at redoing them once they're in Colorado?
It's a good question. It happens all the time when people move here from other states. If your will is self-proving with the two witnesses and the notary in another state, it's going to be self-proving in Colorado. The only thing I would tell you is that it might have an attorney, a local attorney, review it for an hour or less just to say whether they need to make any changes. In most cases, they won't have to, but they should review it just to make sure there has to be any changes made.
We had a lot of different questions about trust. So I know you've talked a little bit about them. I'm going to steer us back there. Particularly, folks are interested in order to access Medicaid, looking at should their assets, their home, et cetera, be held by another family member? Should they be put in a trust? When should you consider a trust over a general will?
I haven't done that many recently, but I have over the years. I represented a woman that owned a huge ranch in Colorado, and her husband had passed away. Her children were adults and now running it. And she lives in outstate Colorado, and they thought if she was on Medicaid, she could stay in a home that would be nice. And so back then it was 3 years. If she had no assets for 3 years, she could get on Medicaid. Now it's 5 years. So you cannot have any assets in your name for 5 years. A lot of people think, well, I'll just try to manage that. But the bottom line is 5 years from now, you can get a Medicaid if all your assets now are moved away. They're given to other family members in a trust for other people. It could be in a special needs trust for later in your life, but you cannot have any assets. You may think that the federal government won't find out about things, but you would be surprised at the things they look at to see whether you had assets or other securities that might be in your name. So you could talk to the lawyer about setting that up, and he or she will tell you how to set that up. And we did that, and the ranch went to the kids, and they now run it. Her mother lived for 4 or 5 years and had a good life in an old home down in outside of Colorado.
And is it enough to just have your spouse hold the assets for the family?
That is a complicated question. Typically, giving assets to your spouse will be a problem. What happens is the Medicaid agency will look at what the spouse has. And I can't tell you now in this discussion as how they do it, but they use a plan to determine how much they look at that is going to be part of your estate. If you want to figure out how to figure that out, call an attorney and he will tell you how that's managed. But part of the assets that you give to your spouse will be considered in what you have in determining whether you don't have any assets.
Is a trust a good idea to set up for long-term care costs if your parents and spouse die and you have no children?
The one thing that's brought up, I'm not sure. I have long-term care insurance, my wife and I, and if we need care later in our life, this insurance company will pay for that if we're in a nursing home or at home getting help at home. Many of them require medical questions. So I'm not sure if you have MS or what level of MS you have early on or later with progressive, whether you can still get long-term insurance. But I think that's something that you should think about. As far as long-term care for you, if nobody's around, the person, you would probably have to do a trust to manage that if you can't do it. And that trustee would manage those assets in order to pay for you, in the end of your life. So that's one way to do it.
I'm also going to give a plug here. We do have a couple of webinars in the past that we've done with another lawyer named Tom Stewart on financial planning, and he discusses some of the long-term care insurance questions. So I would recommend checking out those webinars as well.
I agree with that. I bought my long-term insurance from my oldest son. He's a financial advisor at Oppenheimer.
That's very convenient. Let's see, with a revocable trust with me as trustee and beneficiary, should there's a person who is a trustee and a beneficiary and a successor trustee, should there be a second beneficiary? If you are both trustee and beneficiary, should there be a second beneficiary?
Well, I mean, you could be the trustee and the beneficiary. I guess you could have a second beneficiary that would get the assets if you pass away. But that would be the reason to have an additional beneficiary, I believe.
And can a sole beneficiary also be the power of attorney?
Say that one more time, please.
Can a sole beneficiary of a person, say a child, also be the person's, the mother or father's power of attorney?
Yes, children, in my sons are in their 30s, and they are in the power of attorney and medical power for me if my wife passes away. So my children are, yes.
Can a revocable trust trustee also be the estate's sole beneficiary?
Yes. Although you probably wouldn't need a trust for that, but yes, that would be fine.
Do you know, is there something called a DNV, or do not ventilate, to avoid being put on a ventilator for something like COVID? Has there been anything specific?
Okay, so I talked about a living will, and that is a document, end of life document. If doctors are determined that you're terminable and you have things cut off with that document. A DNA is a document that only doctors can use. You can get a DNA from a doctor and he will do it if you're on a ventilator. But for the doctor to do that, you should call a doctor and ask. He won't do that if he thinks that you may live. And so that's an issue that you need to talk to the doctor about.
We also had a couple of questions come in on the tissue bank. So I just wanted to take a quick moment to talk a little bit about the process for the Rocky Mountain MS Center Tissue Bank. We've been a tissue bank for over 40 years. And what happens with our tissue bank is you pre-enroll with some enrollment forms, which you can get on our website. The link is in the chat. And then once you enroll, you get a donor card that identifies you as a donor of the tissue bank. This is separate from organ donation on your driver's license.
Yes.
So even if you've clicked that you want to be an organ donor on your license, it doesn't let them know that you want your brain to go to MS specific research. When you pass away, if you are eligible and your family knows that you want to donate your brain for MS research, they will contact the tissue bank, and the tissue bank will set up the process. We accept just brain and spinal cord donations. We do not do full body donations. So your family and estate would still be responsible for the rest of your remains, as well as any final wishes you wish, as far as whether you want to be cremated or buried, or any of those things can still happen. And the tissue bank covers the costs related to the tissue removal, but not the rest of your remains. So that's a little bit how the brain donation versus organ donation are separate.
I understand that. That's a great thing, especially for people with MS. And the point, as you made, if you've got that card, you should talk to your family about that so that they would agree when something happens to you. They need to understand that that's what you want to do. And there's also tissue banks all over for different types of cancer and other. So, but it's good. MS would be great for the MS tissue bank.
Absolutely, yeah. Particularly for the MS tissue bank, if your next of kin doesn't call the tissue bank, the process doesn't happen. So please be having these conversations with your family ahead of time. We had a couple more questions come in on finding a lawyer. Looking at online reviews and things is quite overwhelming for some folks. So we were wondering if you had any specific direction you could send people, or kind of a little more specific guidance on how to find an attorney.
Well, we're talking about an attorney for estate planning, and if you look under Google or in Denver, you're going to find a listing of lawyers that do estate planning. When people come to me and come to other people in my law firm or other law firms, most of the time they're referred to us by another lawyer or a friend. So as a person that might be thinking about it, talk to your friends and talk to your family about who do you think might help you with estate planning. That's kind of the way most of my clients come that way. They come from another client that doesn't do estate planning. It comes from a fraternity brother in college. That's where we get people to come in and do estate planning. So I know there's a lot of things to look at on the computer that has all the testing of people. But if you talk around and find somebody, they might give you an idea of an attorney to go talk to. And I'll tell you one thing. I try to return all calls in 24 hours. If you call a new attorney and want to hire the attorney, if they don't return your call in a day, then go on to somebody else, in my opinion.
Excellent. Can you do anything now to protect your home from being sold to pay for nursing home or residential care? And if your family has been living in the home and it gets sold, or can it be sold, evicting them from their home?
I understand that question, and the only reason that I don't know how the house would be sold to pay for health insurance. It would only be as if the hospital or the doctors file a lien to sell the house. The other way would be, excuse me, if Medicaid has a lien on the house to sell it to pay for insurance. If that's the case, it could be sold. And of course, if it's sold, if there's people living in it, they would be evicted.
All righty. Just to kind of, again, repeat a point that you've made earlier, having something as a joint ownership or payable on death is the easiest way for the asset to be transferred to the other person.
Yes, that's one way to do it. And just to make it clear, on the account for securities or in a bank, it could be a pay on death. That means when you pass away, it will be paid to the other person. The other thing is the person might just be a signer on your account while you're alive. If they're just a signer on your account, they won't get what's in your estate. It will be stuck there until probate happens. On the other hand, if you're a joint owner of an account in a bank and the other person passes away, then yes, you would get the money. So you have pay on death, a joint account, or just a signer.
And then could you go into just a little more detail about what a special needs trust is, kind of the uses, and if there's IRS concerns?
An example I did recently, a friend of mine from college, he has a brother who has issues. He can't pay his bills. He works a little bit in a basic job. And so his parents did a will, and they gave part of their estate to this son. And he's now probably in his 50s or 60s. And so I talked to his brother, and we set up, when his parents did the will, we set up in the will that their estate, their assets will go into what's called the special needs trust. And the reason that's important is because it's not considered the assets of the person that needs help. Because if it has assets that are part of that person, they would lose, Social Security, SSDI. And so, and the way it works, there's language. It's a couple paragraphs long that says, here's what we can do. And it says, we're not going to do this, this, and this because that's paid for by Medicare. But it might do a few other things that helps the person, some clothes and things like that, that they allow it to do. Those need to be followed So the Medicaid people and the IRA tax people aren't concerned. It's the language in the special needs trust that they need.
And we are just about to wrap up. One more question, maybe two. Someone was told by their bank where they have a trust officer that they can't make certain decisions as a conflict of interest. Does that sound familiar to you, or?
Well, yeah, I mean, I deal a lot with with banks that have trusts, and trustees at a bank are trustees of the trust that are held by the bank, and they have to act in the benefit to the beneficiary. So the trustee makes decisions for the beneficiary's benefit. If the trustee is asked to make a different decision by another descendant, another brother, another sister, the trustee can't do that. All the trustee can do is what to the benefit of the beneficiary of the trust. And that's what they do as a trustee. They are a fiduciary.
Do you know if a child on SSDI inheriting money could lose that, or is that just SSI?
Did you say that was a child?
A child on SSDI.
Right. What should be done in the estate planning, the will, is they should set up that any assets would go into a special needs trust so it doesn't affect the SSDI for the child.
And then is there, going back to the question of the house being sold with the family living in it, is there anything that you can do to keep your house from being sold or from your family being evicted?
The interest, the problem with the question that I don't understand is I don't know why the house would be sold. The only way it would be sold is if Medicaid had a lien on it because of paying for healthcare, or maybe doctors or hospitals have a lien on the house because bills haven't been paid. If that hasn't happened, then the house won't be sold. You have to know the facts of what's happening, and I don't quite understand that today.
Okay, perfect. A little bit too specific. So thank you, Tom, for all of your time today. Thank you guys for all of your questions. That was an awful lot of really great questions. Again, the webinar will be archived on mscenter.org as well as YouTube. And please make sure that you are signed up on our mailing list for notifications about upcoming educational programming and to get that survey to fill out for this webinar.
And thanks a lot. I had a good time today and good questions today. Thank you.
Thanks, everyone.